Hey folks, Dale Davidson here, the Dear VA guy. Got a couple of letters I want to share with you today. And the first one involves a Q, a clear, unmistakable error. In this case, the veteran had dislocated his knee many years during service, okay? And this was a twisting injury. It's caused him pain and overuse and cold weather exposure and all that kind of stuff. And so way back when, 22 years ago in fact, the VA denied his disability claim, stating that the injury was not service connected and there was no diagnosis. So is that a Q? So we actually researched his C-file and came to the conclusion that it was a Q. This is our response. And remember, Qs are clear, unmistakable errors, and they exist if there's three different requirements under the code, and that's the failure of the VA to find service connection, the error occurred based on the record and the law that existed at the time of the claim, and had the error not been made, the outcome would have been manifestly different. You know, what's interesting about this, and I wanted to share this particular letter with you, is that we have actually filed this Q with the VA. And so in checking with the VA, the first representative we talked to did not know what a Q was. So I explained it. The next time I spoke with the VA, I said, tell us where we are in the queue. We don't have it. Well, guess what? Here's the here's the certified letter that we sent to you, along with all the tracking that says that you signed for it. So you do have it. So we're fighting with them over that right now. So we claim that it was Q back 20 years ago because the VA did not rate him, in fact said that it was not service connected. Well, we went back into his C-file and looked into his medical records and found where that knee injury was documented in 3 or 4 different medical records at 3 or 4 different times during his service. And so we politely brought that to the attention of the VA, saying that it was service connected because the injury occurred during service, okay, and that it was in the record at the time that the claim was filed. And if the VA would have looked at the record at that time, they could have easily determined whether or not he was entitled to some kind of rating for his knee, and they did not. So that was the error in that case. So we're still waiting for that decision, but we feel that because the facts were known at the time that we did file the VA claim, that he filed the VA claim, because it was in his medical records, service medical records, okay. And had the error not been made, the outcome would have been manifestly different. So stay tuned for that one. The next one I want to go over is an interesting one. It deals with diagnosis, and this involves a mental diagnosis. In this case, my veteran suffers from a mood disorder characterized by depression, feeling, and loss of interest or pleasure in usual activities. Okay, now his diagnosis goes all the way back to 1980 when he was clinically diagnosed with depression. He was not diagnosed with any kind of PTSD or anything like that, but his depression has gotten progressively worse, and they call it a persistent depressive disorder. Okay, he's actually immune to medication, so medications he's on are not working. and he's gone through all of these different tests, generalized anxiety disorder tests, other types of psychological tests. And so his question to me was, hey, look, they've rated me, but I feel that I should be rated at 100%. Now, should I file a higher level of review, or should I file a supplemental review? Now, with a higher level of review, you cannot submit any additional evidence. So whatever the evidence is in the file, that's what the VA uses to make your diagnosis or your disability rating. They determine your disability rating. It's not to say that you can't give legal argument, but you can't give additional medical evidence. Now, with a supplemental claim, you give additional medical evidence plus legal argument. So my question to my client was, a higher level of review is usually a quicker review than a supplemental because you submit all that evidence. But what I'd like to do is, instead of giving them additional evidence, we give them the legal argument in the higher level of review, and we put in there in our legal argument references to the record, and we actually see Exhibit A, B, C, whatever it is, and we've highlighted those specific things that we want the VA to key in on as far as making their determination. That has worked in the past. We are hoping and praying that it will work for this individual. Again, he needs to be rated at 100%, in my opinion. Of course, I'm not a doctor, but I've read all of his medical records, and it seems to me pretty clear cut. He cannot do any really activity of daily living without any kind of supervision. He can't drive. His spouse has to go to all his medical appointments. He doesn't go to any kind of family functions because of the stress involved. He doesn't go to the grocery store. He stays at home and sleeps a lot, which is not good for him. So we've suggested here that we go with the higher level of review, but with the legal argument as to why he should be at 100%, referencing the current medical files to get him to 100%. So we hope that'll be successful for him. It's very difficult when you're talking about mental disorders to get to the 100%, although in this case, I think since 1980, he's got plenty of medical evidence to show that he should be. Hey folks, hope you enjoyed those 2 letters that I just shared with you. Hey, check out this video. VA claims success. Consider a higher level review versus a supplemental review. This is going to explain a little bit more detail the differences. So until next time, be blessed.